Welcome to MadGaines Live. I'm your host, Cassandra Gaines. Today we have a very intense show where we're going to talk about FourKites filing a lawsuit against their former employees and against Project44 regarding a non-compete. And y'all know I hate non-competes. I think that they are just, well, first of all, I don't blanket hate them. I think there are limited situations where people can sign a non-compete and it's valid and they're paid to sit out and they're executives. But broadly, having non-competes signed across entire departments, across people who are too young, they don't really they're starting off in their careers. There's so many situations where non-competes are just so not appropriate. And I think that it is an interesting and educational topic that we're going to talk about today. But before I do that, I want to remind everybody that the FreightWaves conference in Arkansas is coming right around the corner. We've got 2 weeks, so hurry up and book your ticket. I will be there. Great Sharky will be there. Everybody's going to be there, so hurry up, chop, chop. We're all staying at the nearby hotels. It's going to be a great conference, and you'll meet a bunch of shippers. I saw a lot of shippers are going to be involved in this. It's about supply chain, so that makes sense. Get that done today. All right. I brought on a special guest. You guys have seen him before. He is a non-compete expert. He is a lawyer. He's based out of Ohio. I want to tell you guys, is usually when he's on, that although we are talking about FourKites losing this temporary restraining order and this lawsuit against Project44, every state, when it comes to non-competes, every state has different laws. The facts could be different. Everything could be different. It's situational based. So this show is based, we're giving you guys some education. Don't take this as legal advice. We are not your lawyers. It's always best to hire a lawyer. And I think everything is based in this topic on Illinois law, but we're going to keep a high level. So I want to make sure I give that disclaimer before we dive into this dispute between FourKites and Project44. So we're going to bring on Brian Redden, and this is who I always want you to reach out to when you have a non-compete issue. He knows lawyers all over the place. He can help you. Brian, thank you for doing the show. I really appreciate it. And welcome back to the show.
Well, thank you for having me again. It sounds like I've done too good a job. I mean, you covered everything. So good to see everybody. Happy Friday. Peace. No.
Yeah, you like deuces. Non-competes suck. Don't sign them unless you get paid to sit out. All right, bye.
At least spend some serious time thinking about it and get some good advice on it before you do it. Period. End of story. And that's takeaway number one. Get your pencil out. Write that down. Talk to a lawyer before I sign one of these things, because as you know, as I know, as this case is an example. Companies, well, I should say some companies are incredibly aggressive about them, and they're going to come after you, even if you really haven't done anything in terms of actually competing. There are companies out there that are chomping at the bit to file lawsuits that frankly like killing trees, and they've got lawyers who are willing to to put together a lawsuit and go to court and start a fight. Whether as the court, and we'll talk in some more detail about it on this FourKites Project44 issue, but whether you've got the facts to back it up or not, it's kind of fire first, ask questions later. And frankly, from my perspective, that's never a good way to practice law.
I couldn't agree more. For those those folks who are new, you've been on the show a lot. You've talked about everything, but usually for those people who are new to the whole non-compete world, could you give us like a high level overview of what you tell people when and how they get into non-compete and what it is, all that jazz, if you don't mind?
No, I don't mind at all, because to that point, there's a lot of bad information out there about non-compete. So we kind of have to start there, right? I can't tell you how many times I've gotten calls, whether it's somebody you've referred to me or they found me on the web or what have you. And, they call and they go, well, I know non-competes aren't enforceable. And it's like, it's not that easy.
Nope.
Not that easy, because, as a baseline, non-competes in most states are enforceable. But as once we get into it and we talk about, okay, well, what's in your non-compete, what it comes down to is a non-compete or let's pull back from that, because you've got non-competes, you've got non-solicits, you've got non-disclosure, and then you've got trade secret provisions. And those all get lumped together. And a lot of times, people who really haven't spent much time either talking to a lawyer or studying it just kind of throw all those things in one big bucket and go, well, it's a non-compete, it's not enforceable. No, as long as it's reasonably tailored, even if it's a non-compete, that can still be enforceable. And you've really got to take the time to dig into, well, what does the agreement say? What are the facts of the scenario? And how do the two apply to what the law is? And then what state are you looking at?
Yep.
I spend the majority of my time in Ohio, Kentucky, Indiana. I'm in Cincinnati. You can see the river over my shoulder. And that's Kentucky right across the way. But that's a pretty big river, and Ohio deals with things one way, and Kentucky deals with them another way, and Indiana deals with them another way. And right now I've got a couple of cases in Illinois as well. And I'm not involved in this particular case, but there's a lot of echoes of at least one of the cases I'm involved in Illinois in this particular case. And Illinois, of a lot of the states that I've practiced in and dealt with these issues, and frankly, I've done it probably in upwards of 20 different states in my career, dealing with freight clients or business clients in other industries. Every state is different. You've got to pay attention to what that state's rules are. And I'll say, to the credit of Illinois courts and the Illinois legislature, they have reined these restrictive covenant agreements, especially as it relates to non-competes. They have reined them in pretty far, and you've got to be careful, especially if you're on the company side, if you're on the brokerage side, or you're on the shipper side, as to what you're trying to enforce. Because just because you have a non-compete doesn't mean a court is just going to rubber stamp it and let you do whatever you want to do.
So what happened with this, with the FourKites dispute? And what did you see? I mean, like you said, you weren't counsel on the case, but you probably pulled things and read it. And what were some of your thoughts?
I killed about a ream. So
I love it.
But it was some interesting. Well, we like to read. It actually, if you're going to talk on something, it's actually helpful to read what it's all about. Nevertheless. It helped cure my insomnia the last couple of nights as I was looking through this. In any event, so essentially the company here, FourKites, sued a couple of their former technology developers that had left FourKites and went over to Project44, who's a competitor in what looks like transportation, logistics, supply chain, software industry. Okay, on a high level, you see that and you go, wow, one company's poaching employees from another. Clearly, there's a problem there. Well, again, not so fast. You need to dig into it a little bit more. So these two particular folks were essentially what I'll call your run-of-the-mill employees. They were not high-level employees. They were not C-suite. They didn't appear to be supervisory level type employees based on what's in the documents. Nevertheless, FourKites filed a lawsuit that was a fairly standard, what I'd call restrictive covenant non-compete complaint. And while it was very well put together, very well assembled, the problem, as I saw it in just evaluating, and all I'm talking about right now is the complaint and kind of their motion for injunction, was that it didn't specifically identify, and I think this is ultimately what the court seized on, it didn't specifically identify any customers, any specific ideas or concepts. There were no employees identified that they pulled away. There was no customers identified that these employees pulled away. It was just the fact that they worked for us. They were involved in our technology. They went over to a competitor and or potential competitor, and now they're working there and we don't like it because they could give our secret sauce away. When you distilled it down to its essence, that's really what it was. And, again, Illinois courts are pretty particular, Illinois state courts, and it should be Illinois federal courts applying Illinois state law should be pretty particular about a showing of either some facts to support the concept of they've taken trade secrets. So, one of the things that was argued, it appeared in this case, based on what I've been able to read, is that there were no specific examples, and I've had this in cases of an employee like downloading contact information, downloading data, taking key documents, things like that. There wasn't any of that, at least in the record that's online available to look at and review. So you've got that issue. Again, no identification of any lost customers, any other employees that were recruited away, taken away, stolen away. So it was just, hey, these employees work for us. Now they're over there working for them. They could give away our secret sauce. That was essentially what it boiled down to. And the court, in what unfortunately is not a terribly helpful opinion, I'm sure the defendants were very happy to get the decision, but it's essentially a 3-sentence order that says the court is denying the injunction. There wasn't a clearly ascertainable right to for the need for protection, and there's not a likelihood of success on the merits. So the court denied the motion for temporary restraining order. To me, interpreting that as kind of a third-party lawyer / armchair quarterback, is there just weren't facts in the record that gave the court a comfort level with saying, hey, there's a problem here, there's some inevitable problem, or there's some actual problem. And, maybe that'll change, because what happens now
they could amend the complaint, and then
they could amend the complaint. They're going to do discovery. FourKites is going to have the opportunity to dig in a little bit and see what Mr. Hightower and Ms. Stokes did, if they indeed did something wrong. And, I've been in scenarios like that.
I have too.
Where
employees have taken documents, information.
100%.
They do it right before they leave. I even had one client who would check. They would have IT department check when people were leaving to make sure nothing was downloaded. And the amount of people who download things is unbelievable.
It absolutely happens. And I've had that too, where you get into the restrictive covenant litigation, and then you're, a couple of months down the road. I mean, I've actually had lawyers on the other side of cases call me, and when we get into document discovery, like, call me and say, listen, I owe you an apology. I owe the court an apology. I know I've said there was nothing taken. My client just came into my office with a box of his documents or her documents, and there's like this treasure trove of, my client's stuff. That happens. So,
Brian, I don't want to interrupt you, but I want to say one thing though that I've noticed, especially when I'm working with people who, or I've worked in scenarios. Again, I'm not like a practicing. I am a lawyer. I've been a lawyer for a long time, right? But
you stayed at a Holiday Inn last night, right?
But that was really quick. Are you drinking beer?
I mean, I've been a trial lawyer for a while. You got to be quick on your feet, okay?
You're right. But I'll tell you, sometimes when these are like people's first time they're leaving the job, they think to themselves, I spent so long like working with these customers. I want their contact information. I want my presentation that I made like 3 times. Like, there sometimes people they just think like, this is my stuff and I want to take it with me. And they don't think like, and they don't know that, oh, by the way, 3 years ago when you started this job, you signed this big long document that you probably didn't even know you signed, that says you're not allowed to have any of this stuff.
That's
and you're not supposed to take it. And I'm just a kid in sales. And I'm like,
And like you said, it's my stuff. I mean, this customer has become a good friend of mine, especially if it's a local, if it's kind of a local deal, if it's somebody that, I'm their logistics guy, I'm their broker, I'm moving their freight, and they're 20 minutes up the road in, Blue Ash or Kenwood neighborhood of Cincinnati, or, they're in, Goodyear in Phoenix, and you're in downtown Phoenix, and you've got fantastic relationships with them, and you go and you get drinks and you hang out, they become a personal friend. Now,
like, oh my
that blurs the line a lot, right?
Mm-hmm.
So you get into those scenarios where, well, maybe it went from just a customer, a customer broker relationship to an actual friendship. So, is it those personal relationships get a little bit sticky? But the documents, the rate sheets, the freight orders, the bills of lading, the POs.
Yeah, that's a whole other ballgame.
All those
oh my
documents.
God.
That's a whole different deal. And if it's like, well, I was just using the history from my friends, but nope, sorry, that ain't gonna fly.
Yeah.
But you're right. I mean, data these things are everywhere all the time, 24/7. They're in our hands. They're next to our beds at night, and we're answering them at midnight. And at 6 a.m. you pick it up, and it's the first thing you do, right? So, that gets into a bit of a sticky area. But what I tell people when they call me and they're saying, "Listen, I'm thinking about leaving XYZ and going to ABC." Okay, that's fine, but you got to leave pockets empty. Don't take your computer with you. Anything that the company, if you have your own independent computer, anything that the company document, you got to get it off there. It isn't worth the time and the trouble, because one relationship that you've got to step away from. And this is where we get into the non-solicit piece, right? One relationship that you've got to step away from, if that person was a friend in 2022, they're still going to be a friend in 2024. And if it's a year non-compete or a year non-solicit, if that relationship and that bond is that tight, they're still going to be there down the road. So that business isn't gone forever.
So much sense.
And the cost benefit, and what it comes down to is that cost benefit analysis. Like, listen, I don't want to talk myself out of business, but isn't it better to not have to worry about getting your new employer involved in litigation and you involved in litigation and spending six figures on defense, where you got to get somebody like me to come in and fight the fight for you, than just saying, okay, let's just be friends for a year, and then we can start doing business after this thing is up.
I asked a friend recently, and I do this a lot because I hate non-competes. I think that there are limited situations, like I said at the beginning of the show, where non-competes are fine.
Right.
And that makes sense. Whatever, there was compensation. Both individuals were educated entering into the agreement. They weren't 21 years old signing onboarding documents and didn't even know what the hell they signed. Or they got their bonus that they were promised every year that includes a stock grant, but it happens inside the stock grant document that there's a non-compete.
Yeah, where it's buried on page 24 of a 38-page document. Sure.
Yeah, it's kind of slimy, and I feel like I feel as though I wish that there was more protections for employees with situations like that. But setting that aside,
it's coming.
Oh, good.
It's coming.
You think so?
I absolutely do. And we're seeing it in numerous states. I just did a quick look last night. These are the exciting things I do in my off hours.
I actually believe that, by the way. You're a total nerd. Even though you come off really cool.
Yeah. I don't even know. I mean, honestly, I don't even try to hide it. When you're a kid, you try to be like, I'm actually really cool. Now it's like, no, I'm a dork in this area, and that's fine.
That's what make me good. That's how I make my money. So fine.
That's right. That's right. So right now we're seeing it in Oregon, Nevada, Virginia, Maryland, District of Columbia, and more. I'll just say and more.
Oregon, Nevada.
So Oregon, Nevada, Virginia, Maryland, DC have all banned or limited non-competes in certain areas, or in certain wage classifications, in certain responsibility classifications. Now, is that going to apply to the C-suite? Is that going to apply to like senior management below the C-suite? No, because those folks, they've got access to the important stuff, the secret sauce, right? Again, kind of touching on the FourKites P44 thing, right there, we weren't talking about the chief information officer. We weren't talking about the project lead that developed this software. You were talking about people that were mid-level or lower. That's a big difference. That's a big factual difference. That's a big
one hadn't even been there for wasn't she only there for 11 months or some crap? I don't know.
Maybe 8 months, and I think the other one was there for 14 months. But Cassandra, I see it all the time. I see it all the time. where someone is at brokerage X for 14 months, and they go somewhere else, and let's say they sit out for 3 months, and then they go to another brokerage, and the former employer brokerage comes in and says, "We've got a 2-year non-compete," and you're like, "Oh, wait a minute." She wasn't even there for 2 years, and you're trying to keep her out for 2 years on a blanket non-compete. That, courts, even in Ohio, where courts, I don't want to say they favor non-competes, but aren't as hostile to non-competes as, and again, I'm not talking about non-solicits, I'm talking about non-competes.
Right.
Courts are going to be very reticent to cram down a 24-month non-compete on somebody that was only there for 14 months. Judge, I had it last year, and I had tremendously good facts. Now, this wasn't in the transportation industry. This was in like home repair industry, plumbing, as a matter of fact. And I actually had these are the facts I had. The employee who left my client, went to a competitor, had photographs of the specs for the job on his phone, went back after he changed jobs, sold the job for his new employer, then posted online the pictures of the specs. Okay. So I could show our specs from when he was there speccing it out for us, their specs for when he was speccing it out for the new employer.
Oh, no.
Right. The court refused to give me the enforcement on the non-compete, saying it would chill competition. Now, this again is Ohio, where courts are not tremendously against non-competes like they are, especially in Illinois and some other states. I was stunned. As a matter of fact, it's the judge who was on that case I've known since high school. I went to high school with the judge, and I'm like, really? Like, I mean, facts don't get a lot better than that. I mean, it was close to a smoking gun.
I did not expect you to say that.
Well, trust me. It's fundamentally unfair to hold plumbers to non-competes.
What about the rest of us?
But that's not the law, right? That's not the law. There's no exception for plumbers. Fortunately, lawyers, there actually is an ethical rule, at least in Ohio. I don't know about other states, but at least in Ohio, lawyers cannot sign a non-compete. It'd be an ethical violation. So, we were smart enough to carve ourselves out of this whole problem. Nevertheless.
However, I would like to warn some of the lawyers out there is that when I was at Schneider, I got like an excellent performance review, and I was all excited, and they offered me my stock, and in the stock was a non-compete. And I said, well, I can't sign that because lawyers aren't allowed to sign non-competes. And the guy.
But you recognize that because you actually read the whole damn thing, like a good lawyer would do.
I had a feeling because they're always hidden in there, and I'm like, nope, I can't do it. Here's the rule. You guys all know this. The GC was like, oh no, Cassandra, we're actually making everybody sign for your level. We're making everybody sign a non-compete. Well. And he said, well, by Friday, if you don't sign this non-competes, then no more job for you. And I had said, I was like, well, I can't. And I said many times I can't. And I showed them the rule, not like I have to, since they were all lawyers that I was working with. And they still stuck with it. All the other lawyers told me that they signed the document except for me. Wow. And I got fired for it. And I love Schneider, but that was the end of my Schneider career. And anybody who Googles this would know this about me, but I ended up suing Schneider for it. And I lost in the court.
As you should.
Yeah, but I lost. And I'll send you the opinion. It was really weird. And the court had said that our rules of ethics are not I wish I had the language with me. They're not like a public, our rules of ethics are like,
that's for like attorneys in private practice, not for in-house.
No, they said it's not like it's a public enforcement. Like it's not like it's a state statute. It's just rules of ethics. Oh, they viewed it more like it's our ethical rules. It's a whole nother situation. It's not like it's a statute that's against statute. Not interesting. I'll send you the thing. But I just wanted to warn lawyers, especially those in-house ones that are watching this, is that be careful when you sign your documents, you get your stock and whatever else. And if you're freely signing non-competes, these situations are not easy for us either. And it's very interesting. A little digression there for people.
Now, the one thing I would say, though, is Illinois, like Ohio, like Kentucky, like Indiana, all these states have adopted some degree of the Uniform Trade Secrets Act. So, and we would be bound by the Uniform Trade Secrets Act no matter what, because that's a statute that applies to anyone in an employment situation.
Ooh,
we don't get the.
That's a smart argument.
Like I said, I've been doing this a little bit. So
yeah, that's a really smart argument.
That statute's going to apply regardless. So, you're not, it's not like, hey, I'm a lawyer, nothing, you can't do anything to me in that scenario. If there were confidential, proprietary, trade secret info that, had some value that could be taken to a competitor and you go, I'd argue there, even if there isn't a non-compete agreement or even an employment agreement in general, you'd still have some applicability around the Trade Secrets Act that, would be out there.
Interesting. So, question for you. Well, first of all, before I dive into my questions that I know everybody else is going to want to ask you, you did have a big stack of papers. I want to make sure that was there anything else you wanted to tell us about or that you noticed? And if there was nothing, that's fine. I just don't want to miss anything.
Just, I guess the big lesson from these cases is, if you're analyzing and you're working with your lawyer or you're trying to defend one of these, I think the big question is, like, the law is the law, but what are the facts of any given case, right? What gets lost, at least in my mind, a lot of times around these types of cases is, well, you signed an employment agreement, and that employment agreement said you weren't going to go to a competitor and you weren't going to do this in the whole transportation logistics industry. Like, well, okay, time out.
Yep.
Let's roll that back a little bit. Let's look at, okay, individual X, employee X was a salesperson here. They go to company B, and at company B, they're purely in operations, back of house. They're involved in no sales role, and company B gets it, right? I mean, I can't tell you how many times I've had this discussion with clients. Like, hey, we've got a nasty gram because we hired John recently, and he was a sales guy over here, and now he's purely doing ops over here. He's having no external contact. He's not selling anything. He's not quoting anything. All he's doing is making sure that, loads are arriving on time and things are going where they need to be. If there's no client contact, if there's no real, like, meaningful threat that customers are going to leave company A and go to company B, man, a judge is going to have a really, really hard time saying, yeah, I'm going to keep John from working over at company X. Now, before you take that leap, before you file that lawsuit, you better be damn sure you've got strong facts to bring the case. You better make sure that there's at least the realistic threat of damages, and you better be able to prove it to the court. Because, I'll say 10 years ago, courts, especially at Ohio, Kentucky, Indiana, they were pretty good about, from the management perspective, from the former employer perspective, about giving injunctions in this space. I'd say in the last few years, courts have pulled back from that in general and said, you better come with some pretty strong facts.
Yep.
And they're not going to be so quick to grant that relief.
What sucks though, Brian, is for those of you who are out there listening and you're like, oh, okay, because I have a non-compete and I was just a carrier sales rep and I didn't steal anything, I didn't solicit, and I didn't do anything. Here's the problem, is that sometimes it depends on your employer you went to.
Yeah.
And it also depends on how much money you have, because at the end of the day, even if everything, which it is, everything that Brian's saying works in the favor of the former employee who's now got themselves in a situation, you still got to hire a lawyer. It's probably going to cost you about 10 grand if you're lucky, just for the initial phases of everything. And then you got to have the new employer has to be able to feel comfortable with standing by your side, hiring a lawyer as well, because they're on the line.
Yeah, because clearly here, P44, to their credit, and I've had some, I've got multiple cases right now to these clients' credit where, the new employer stands by these folks and says, you know what, we value this person as an employee, and we've respected the non-compete, we've respected the non-solicit, we've respected what they're allowed to do and what they're not allowed to do, and we're going to stand with them. But, there have been times, and I've been on both sides of this, where, the new employer just goes, you know what, we don't want this noise. We don't want to deal with it. We don't want anything to do with this.
And there's not as big as an ROI on that employee, a return on investment on that employee too. Right now, employees have a lot of power because it's hard to find the employees, blah, blah, blah. And it depends on the employee. But if you're just somebody who's easily replaceable, they're really not going to go to bat for you, probably.
Probably not with what we cost. I mean, at the end of the day, I was talking with a client on a similar issue on this. Like, does it make sense to file a lawsuit? And I said, listen, I know you love spending time with me. I don't know that you love paying my hourly rate to spend time with me. And you better make sure that if you're going to go down this road, that you're ready, willing, able, and comfortable to be writing significant checks to get this thing done. So, in the first 30 days, are you ready, willing, and able to spend 20 to 30 grand if the former employer is very aggressive? And if they are, okay, cool, let's do it. But if you don't think that ROI is there, new employer, I don't know that it makes a lot of sense to go down that road.
Yep. Unless, I think you said it perfectly right there. And so let's wrap up with one good question. And we'll, obviously, I think we bring you on we're bringing you on category the same topic, but it's only because it comes up and it comes up and it comes up, and I keep trying to bang it into everybody's head. Pay attention to this, you guys.
Like you said, when good people are hard to find and recruit, there's a lot of recruiting out there. People who are successful one place are going to be successful another, and they're going to be in demand. So it's going to be happening a lot over the next couple of years. Absolutely, 100%.
And so I want to tell people. Okay, question for you before I dive into my question. Well, actually, I'll do the question first. So if I'm going to flip it around. Usually we're employee centric. Not usually. Sometimes depends on what you and I are talking about. But, and I want you guys, Brian Redden is easily available on LinkedIn. You can just Google him. You can message me if you can't find him, and I'll give you his information. He's who I send everybody to. And if he can't help you, he easily, he knows who the people are in this area of the business. I think you do a lot more than just non-compete. I think your whole firm does a lot of stuff, right?
I do.
I didn't want to pigeonhole you, but at the same time, you're good at this too. So if I am an employer, and I'm hiring people a lot, and I'm bringing on I'm so excited about my growth, right? What would your recommendation be? Should I ask employees if they have a non-compete, or should I do head in the sand, don't ask?
No, absolutely. 100% better to ask, find out, get a copy, and analyze.
You do want them to get a copy.
Absolutely,
okay.
without fail. Because listen,
I don't even know.
Well, and if they don't know, they don't know. But if you get it and you can analyze it, and again, you make that ROI determination, right? If you really believe that there's an employee that is worth the potential fight, it's better for you as the new employer at that point to analyze the issue and get that potential new employee instructions, if you will. Get with your counsel, with your legal counsel, and say, okay, we're interested in hiring Cassandra. She's an ass kicker. She's great. She's going to bring in tons of business, and it's going to be worth it. Okay, so let's plan how this is going to work. You're going to make sure that you don't have files on your phone. You're going to make sure that you don't have files on your home computer. You're going to make sure that you don't have papers and documents and records in your car or in your office at home. Because as we were talking about before, so many people are working from home now that that whole line between keeping stuff at the office to having stuff at home has just been blown up.
It's so blown up and blurred.
So, and that's a huge risk too, right? Because records could be everywhere. So we've got to make sure that these things are thought through, considered, and you've got a plan for how you're going to deal with it. Because at the end of the day, if you don't have a plan, then you're setting yourself up for problems down the road.
And for those employers who are out there and you do have non-competes and you still believe in it and all that stuff like that, it is still best that you have a lawyer like Brian review the non-compete language.
Absolutely.
Changes. All this industry is always just areas.
If you're still using the same non-compete that somebody drafted for you in 1995, employers, you're asking to get punched in the mouth at some point, probably sooner rather than later. Absolutely.
Even if it's 5 years old, I think you should still but I'm always like, if I'm going to have somebody sign something, I want it to be enforceable when I'm ready to enforce it.
Yeah. So whether it's an employee handbook or agreements like this, I tell my clients, we need to look at it every 3 to 5 years, 5 years max.
That's
and
smart.
If you haven't, then you're asking for trouble.
Yeah, that's smart. Very smart. So I'm going to leave everybody with this final note. And it's going to be, for those employees who are listening, the places that are, if you're like, shoot, do I have a non-compete? Like, did I sign a non-compete? Am I going to sign a non-compete? If you have stock in the company, odds are some point in time, there's a non-compete section hidden somewhere in there. You reach out to Brian, talk to him. He has strategies on how to figure out. He's got all sorts of stuff for you. That's who I send my people to when they're like, I don't know, and I'm scared to ask if I signed a non-compete. But you need to know if you signed one.
You need to know.
You're gonna be surprised when you go to another company, all excited about your new job, and your former employer pops up and says, "Hey, you can't work for them." And the other thing is that when you're onboarding with a new company, there's a lot of paperwork. You need to tell the recruiter clearly, tell them, I will not sign a non-compete, and blame it on somebody. Say, I have a family lawyer and they refuse to even let me, or my mom's like, just lie, do something. But just, if you want to make another person a bad guy, say Cassandra will punch me in the face and she knows me. But you've got to, and there's ways you can curtail. If you're forced to sign the non-compete, call Brian. He will help you negotiate the language and narrow it down. Because if they fire you with no compensation and they tell you to get the hell out of the building, that non-compete you signed could still be enforceable.
Absolutely.
Brian would tell you.
Absolutely.
Or you're going to pay a lot of money fighting it. So I want everybody to remember that, because people get blindsided. And Brian, we'll keep hitting people over the head with this knowledge.
Banging the drum.
Again.
Keep banging the drum. Listen, non-solicits, fine. Trade secrets, fine. We can tailor those and make those smart. I'm telling my clients, don't even go down the road of a non-compete unless it's a serious C-suite or very key person, because you're just asking for trouble.
Yeah, you are. And I guess if you want trouble, you can get it too. Thank you so much. Everybody knows now how to
my
find
pleasure.
you.
Thank you.
And we'll see you again.
Happy to.
This topic always comes up, and you and I have to educate people again and again. But thank you. I'm glad you came. And everybody, happy Freight Friday. And make sure that you all buy your ticket and head to FreightWaves event, which is coming up very soon. Have
a great weekend.
In today's tight freight market, it can be challenging for freight brokers to manage capacity. That's why Time TMS has partnered with Parade